Did you realize that Malaysia has become the focal point of major constitutional issues in the last few years? We have had all sorts of issues that have assailed the nation. Last week we had another. Hi, I'm GK Ganesan and this is GKtv. Today's subject is, was the current Speaker's appointment legal? On the 13th of July, Dato' Azhar Harun was appointed as the Speaker of the Malaysian Parliament. I use the word appointed advisedly. A number of constitutional questions arise from this so-called appointment. The first is, was the previous Speaker removed lawfully? Assuming that he was, how should the new Speaker be appointed? Is there a procedure for it? The second question is, did the MPs follow the procedure set out by the law? The third question is, if the Speaker had been appointed by processes outside the law, what relief is available to the MPs in Parliament or to any ordinary citizen? And lastly, can this dispute be taken to court? And if yes, what relief can the court grant? The short answers to these questions are, as to the removal of the previous Speaker, was his removal lawful? I do not think so. The MPs followed procedure, but they chose to overlook the spirit of the law. The previous Speaker's removal was against the rule of law. He had done nothing wrong. There was not a single whiff of any allegation of misconduct against him. So why remove him? There was no reason to remove him at all. Now let's leave that question and move on to the second question. Is there a procedure for the election of a new Speaker? The answer is yes. As to the third question, was that procedure followed? My answer is no. So what's the consequence? In my opinion, and it's only my opinion, the appointment was outside the law and Parliament does not have a Speaker. The next question is, so what? What's the legal consequence? My answer is, any decision made by Parliament after this period would be, in my opinion, void and illegal. So, what can the opposition do? What can anyone do? Can they seek any legal remedy? My answer is yes. There are two independent solutions to this problem. It is said, I don't agree, but they say, one is to move a substantial motion to remove Art Harun. The other relief, with which I agree, is to go to court and to ask the court to declare that the Speaker's appointment is invalid. Can it be argued that under the principles of the separation of powers, the courts are prevented from interfering with what happens in Parliament? Well, my answer is no. If it's a matter of law, it's only the courts that can answer whether any law has been breached, and if so, what the consequences should be. Now, I've given you short answers to all these important questions. Would you like to know what my reasoning is? Why did I come to my conclusion? Let's deal with the first question. Is there a procedure to elect a new Speaker? Well, we start with an important point. The need to elect a Speaker, and note the word elect, is a crucial duty of Parliament. Why is that? Parliament cannot do any work without a Speaker. Article 57 of the Federal Constitution forbids it. This is what it says. The House of Representatives shall from time to time elect, note the word elect, as young Di-Pertua Dewan Rakyat. And Parliament, it says, shall transact no business while the office of Speaker is vacant. There is, however, an exception. Parliament can meet, but only do one thing, elect a Speaker. That's what the Constitution allows. Now let's deal with the word vacancy. When the previous Speaker was voted out, a legal event occurred. The standing orders of the Dewan Negara, Order 3, declares it as a vacancy. So what? The answer is, the moment there is a vacancy in the position of the Speaker, the law requires that the House shall, as soon as a quorum is present, proceed to do what? Elect the Speaker. So what's a parliamentary quorum? Well, under Order 12, Sub-Order 2, the quorum is only 26 MPs. What is the procedure for the election of the Speaker? Well, Standing Order 4 lays out the procedure. Once there is a vacancy, a notification procedure exists. If any member of Parliament wishes to propose a nominee, he shall notify the Setiausaha who is the clerk of the House, of his proposal. It must have two characters. It must be a written proposal, and secondly, it must be lodged with the Satyasaha or the clerk of the House at least 14 days before the next meeting. That is regulated by Order Sub Rule 1. Now, if we follow this procedure, the moment the previous speaker, Sri Ariff, was removed from office, his position became, yes, you're right, under Order 3, his position became vacant. No parliamentary work could be done in the absence of the speaker. That's Article 57, subparagraph 1 coming into action. The next meeting date has to be set. It has to be timed for at least 15 days after the removal of the previous speaker, after the written proposal is sent to the Satyasaha of the Dewan Rayat. At the next meeting, 14 days after the lodging of the notice, another MP who wishes to propose some other member shall rise and state that I propose that, and name somebody, Mr. X, do take the chair of this House as Speaker. Now, his proposal must be seconded. If only one person is proposed in this way within the 14 days and seconded as Speaker, then the Satyasaha or the clerk of the House shall, without putting any questions to the House, declare that the candidate to have been duly elected as Speaker. If more than one member or persons are proposed and seconded, then the House shall proceed to elect the Speaker by ballot. Now, if we apply these principles to what happened in the House of Representatives or Dewan Rayat on July the 13th, we note the following. First, the former Speaker, Sri Ariff, was voted out. Second, the Speaker's position thus became vacant. Third, the Dewan Rayat then became obligated to comply with Order 4 as I have outlined it before. So the next question is, did the MPs follow the procedure in Order 4? The answer is no. Nor did the Deputy Speaker, then presiding, allow nominations to be proposed to the Satyasaha or the Clerk of the House under Order 4, Sub-Order 1. There was no notification to the Satyasaha in writing at least 14 days before the next sitting. This, I think, is a serious breach. The next question is, so what's the consequence of this breach? Well, in that case, in my opinion, no speaker has been elected. Now, I have heard contrary arguments from government MPs. What are the pro-government MPs' arguments? Let's rehearse them. The first argument is the irregularity point. These MPs say that any failure on the part of the House to comply with the standing order is a mere irregularity. It was only a failure to nominate new candidates for the position of Speaker. Such a failure, they argue, is not a nullity, it's only an irregularity. It doesn't nullify the proceedings. Now, they are quoting Order 99 capital A. There is a weakness to this argument, and it's a fatal weakness. There was no decision of the House on the 13th of July electing the current Speaker. So what decision is anybody talking about? Second, there was no election that was carried out. Third, Art Harun was nominated in breach of Order 3. Fourth, there was no notice procedure and Art Harun chose to take the seat of Speaker without compliance of the standing orders. But I'm not worried about all that. I am worried about something that is seriously wrong. And that is in Article 57, which requires the Speaker to be elected. And then Standing Order 3 also uses the phrase, the House shall proceed to elect where a vacancy occurs. Now, the word shall in that sentence means an election is not an irregularity, it's compulsory. Now, the next argument is the Speaker's decision is final. They say that the decision of the Speaker upon any point of interpretation of any standing orders or practice shall be final. They are quoting Order 99 of the standing orders. Unfortunately, the current Speaker cannot make a decision about his own appointment. That would be in conflict, wouldn't it? And this new Speaker, in addition, didn't make any ruling on any point, on any of the standing orders on the 13th of July under Order 99. The last argument is, the government MPs say that the opposition MPs have to move a substantive motion to challenge the Speaker's decision in taking the chair. Again, I must say, the Speaker made no decision on any point of practice or interpretation of the standing orders. So that is out. But let's take this important point. Can this dispute be taken to court? Well, the starting point on this question is Article 63, subparagraph 1 of the Federal Constitution. It reads, "The validity of any proceedings in either House of Parliament shall not be questioned in any court." Oh, that seems to suggest that nothing can be done. Now, that clause comes from a very old law. It comes from Article 9 of the English Bill of Rights, 1688. Now, this tension between what the courts can question about Parliament and the immunity of parliamentary proceedings from any interference by the courts has existed for hundreds of years. Now, under the principle of separation of powers, the executive, the Prime Minister, the Cabinet, the civil service or the government of the day, and the legislature, meaning Parliament, and the judiciary, meaning the courts, cannot question what happens in each other's institution. There is a separation. Now, although there is always an overlapping of functions and powers between these three institutions, Parliament, the judiciary, and the executive, for the most part, do not interfere with each other. Now, over hundreds of years, the UK courts, whose laws we follow to this day, have held that the courts will not interfere with the workings of the House of Representatives unless there has been a breach of law that regulates the conduct of Parliament. For those of you who are listening and who are legally trained, the question is called the question of justiciability. What justiciability means is whether the courts can examine the conduct of parliamentarians within Parliament in a court of law. Now, this presupposes that some questions are completely beyond the control of the courts. Well, in a number of cases, the courts all over the world have held that they will not interfere with the separation of powers or with the workings of Parliament. Now, last year, in 2019, the British Prime Minister, Mr. Boris Johnson, prorogued or postponed parliamentary sittings by more than a month. He used his powers as the Prime Minister. He said he had prerogative powers. The Supreme Court overruled him. You might think that this is a new development. Not so. For example, in the year 1610, in the case of proclamations, the courts protected parliamentary supremacy. They acted against the king. The UK courts ruled that a monarch could only exercise powers that were allowed to the king by the rule of law. There, the king in 1610 had tried to use his prerogative powers to change the law of the land. See, what he did was he tried to stop new buildings being constructed in or around London. That is a case of the courts limiting a monarch's powers. Imagine that. Now again, as far back as in 1765, the court stopped the government of the day from indiscriminately searching private properties for seditious material. This was in a case called Antique versus Carrington. Even in Malaysia, where it was thought that the court had no power to intervene, the courts have in fact intervened and set the law on its right course. Now, the Malaysian Federal Court, in the case of the Speaker of Dewan Undangan Negeri of Sarawak, Datuk Amar Muhammad Asfia Awang Nasir versus Tin Tiong Chun and others in the year 2020, made this statement. One of the judges of the Federal Court said, "Though the separation of powers doctrine applies between the judiciary and the legislature, this separation, in my view, is subject to the Federal Constitution as it is the supreme law of the land." In other words, if the respondent had not been given a fair hearing and thus became a victim of a breach of natural justice, there is nothing to stop the court from intervening, as the legislature is constitutionally bound to adhere to the order of law. Any contrary view, said the judge, would lead to anarchy and lawlessness, a result which the courts must prevent at all costs. That, I think, will become very useful when this case goes to court. But 10 years earlier, in Gobind Singh versus Yang Di-Pertua, Dewan Rakyat and others, Parliament suspended Gobind Singh's remuneration. The Federal Court allowed Mr. Gobind Singh MP's application for his parliamentary allowances to be paid to him because There was no law in that area. The federal court was the only court in the land that could interpret the Constitution. But here is a question that is not being discussed. Suppose an MP goes to court and asks the court to interfere. But before the court can make the decision, the Prime Minister decides to call for a sudden and snap election. What happens? The government will argue that any question on the Speaker's election would become academic. The government will say that the new election will give rise to a new set of parliamentarians who would in turn choose their own Speaker. The answer to this question is simple. Whether or not parliamentary procedure had been breached in the appointment of a Speaker is not an academic question. It goes to the root of constitutional provisions. The case will raise questions whether we as a nation have complied with the principles of the rule of law, with the provisions of the federal constitution, with the standing orders of the Dewan Rayat, all of which our forefathers bound themselves to comply with. The second problem I foresee is, and it's a little unfortunate, the AG would have to argue the case on behalf of the government. At any rate, he would have to appear before the federal court and give his views as the Attorney General. That would put the current AG in a state of discomfiture because a member of his family would be involved in the decisions over that questions. Now, these set of circumstances should give rise to an interesting constitutional conundrum before the courts. The question is, will the opposition raise this point in the courts? And if they do, how will our courts respond? Well, we wait for the next move, snap election or no. I'll see you shortly, in a few days, with another interesting constitutional conundrum. Thank you for listening. Goodbye and have a good day.